2015. This is our 11 a.m. session. I have the first item for you, Chairman.
Yes.
This is Brett Austin and Joshua Forty. This is contract purchasers, 12 to 14 East Cross Street. This is a Class BD7 for your wine and liquor license. Request for hardship extension under provisions of 2B 10540A and a remand from circuit court regarding the transfer of ownership. I believe the parties are here. Please step forward.
Which one is this, Boston Street?
Yeah.
Boston?
He's looking for Boston Street. That's been postponed.
He was postponed. Yeah, we
need to just
put it
let
up.
the judge
Boston Street is postponed.
Yes, sir. The first item, Boston Street, was postponed, and that item has been placed, it was sent out in an email for, but this item has been postponed.
Okay, and this is Cross Street?
This is Cross Street, 12 to 14 East Cross Street.
Okay. All right, folks, enter your appearance, please.
Good afternoon, Your Honor. My name is Joe Woolman on behalf of the licensees.
Good morning, Judge Ward, members of the board. My name is Patrick Nickel, and I'm here on behalf of the Federal Hill Neighborhood Association.
All right, would you spell your name again, please?
First name Pat, last name McNichol.
Is that after Patrick?
Yes, sir. Last name McNichol, MCN.
MC, that's what confused me. MC?
N as in Nancy. ICHOL.
Okay. All right. Now, who wants to go first?
Well, Your Honor, I have a preliminary matter that
All right.
perhaps the board should consider initially. Just by way of introduction, I have the licensees as well as our neighborhood consultant standing to my right out.
Are they going to testify?
Not necessarily, Your Honor. I just wanted to introduce them. They're here.
Okay, sure.
See if that's more comfortable for them.
Go
I
ahead.
don't plan to call them during the preliminary argument. As Your Honor is well aware, we filed a motion to dismiss this matter. And it's interesting because you have two issues before you today. You have this quote-unquote remand. I think it was actually a stipulation of dismissal. I would characterize it more than a remand. That's the one issue you have before you. You also have the hardship request, which we were here before you a few weeks ago, and you consolidated the two matters today. And I think it's interesting because the subject matter in the background regarding the motion to dismiss also has a lot to do with the hardship, because certainly these licensees have endured a long history of hardship in this matter. By way of background, this license was originally purchased from a small corner bar named Turner's on Cross Street in 2009. The license was initially meant to be moved to a location on Charles Street, and due to various issues and difficulties, the licensees weren't able to complete the deal with the property owner on Cross Street, and hence they've now acquired additional properties. I'm sorry, on Charles Street, that portion of the deal didn't go through. They've then acquired additional properties on Cross Street, and that's the project that has been ongoing for a number of years now, and is the subject property that is before you today. There's been numerous protests, numerous renewals of the license every year, and I think that's key if we get that far.
I know it has nothing to do with it, but that Charles Street property, that wasn't the old Stonewall Club, was it?
Does anybody know the answer to that?
Was not.
No.
Okay, go ahead.
It's an old dilapidated service station. At least that was the last use from what I can tell by just looking at it, and it's actually owned by another client of mine. However, back to my point, there's been a long history. There's been a lot of hardship faced. I know we're not at the hardship phase of the hearing, but I think it's important by way of background. There was even a protest in 2011 by this same group regarding one of the renewals. That's just another example of the hardship that's been faced. There's been a renewal of this license every year since 2009, and I'll later introduce that to the record again if it's necessary. The validity issue, which I believe is the limited scope of the subject matter before the board today, was first raised in 2013. There was a motion made by this same group, different council at the time, but by the same group, to ask the board to rule on validity. And the board denied that motion and denied the transfer at that time for an earlier version and an iteration of this project, if you will, that contained a much larger capacity. It was a larger place, and my clients lost at that point. Despite having failed to have the transfer completed then, and despite the fact that protestants prevailed in their case in chief, an appeal was taken to the circuit court in 2013 on the board's denial of the validity issue. And this is where we really get to the crux of my reason for a motion for dismissal. Back in 2013, this first appeal, I'll call it the first appeal, was taken. And counsel for the board at that time, still the counsel now, and myself both appeared in front of a circuit court judge and argued a motion at that time, at which time the court reviewed the record in the 2013 hearing, and the court, not a stipulation of dismissal, but a judge sitting and hearing from all parties. Again, there was a different counsel for the neighborhood at that time, but a court had a hearing, heard from both sides, and determined that the matter should be remanded back to this board for a hearing and the creation of a record on the validity issue. That hearing was held on February 20th of this year. It was, I believe, 3 hours plus. There were some 26, 27 pieces of evidence received and marked and introduced and accepted by the board. There was a substantial record created at that time on the issue.
I think the court also said it should be heard in 30 days.
Yeah, it had to be heard within 30 days, and which basically at that time meant the month of February, and we heard it at the very end of February, just making that deadline, Your Honor. And again, a very substantial record was created at the request of the judge. There was no stipulation between the parties at that point. It was a judge that heard the matter in circuit court, and the judge remanded the matter to this board, at which time the record was created. February 20th, we have that long hearing. The board makes its decision based on that substantial record to find the license valid. The protestants file a second appeal to circuit court, and this is where it really gets interesting, Your Honor. Despite the Maryland rules to the contrary, the board, and it was a different staff then, I apologize, the board never notified the licensees of this appeal being taken. The licensees learned from other sources that an appeal.
He points out in his response that you have a letter 10 days later in which you acknowledged having knowledge of the
As I was about to say, Your Honor, you're correct. We found out through other sources that an appeal had been taken. We didn't receive a copy of anything, and going forward, we never received a copy of any pleadings of any kind. Most importantly, and really
At that point you knew.
We knew. We knew an appeal.
So what's the point?
Well, the point is this. The point is, at that point, we were preparing to insert ourselves into the appeal.
Whatever it is, you knew.
We knew. We knew at that point. We wanted to insert ourselves into the appeal, obviously, because the licensees spent a significant amount of money and resources to obtain this license and develop this project. So clearly we had an interest. We were a little concerned that we weren't being brought into the conversation as a party to the hearing below by the board's counsel. And the reason I bring all this up is, until I met with your new secretary, executive secretary, we were preparing to go to circuit court, Your Honor. We were preparing to go and argue that the record created on February 20th, 2013 was sufficient, and under the law, which provides great deference to administrative agencies, as you know, we feel the court should have upheld the decision reached on February 20th. Again, unbeknownst to me, and this is really the upsetting part, Your Honor, and I mentioned it a few weeks ago, and I think you raised your eyebrows at that time. Counsel for the board met with or discussed with counsel for the protestants a stipulation of dismissal without notifying us of any of this. Here are my clients who have been trying to develop this project since 2009, spent 6 figures on this liquor license because it's in the restricted Federal Hill area and had a lot of value because of that. And we're preparing to go to circuit court because you're right, we knew there was an appeal, and we're preparing. I came in to meet with the secretary of the board and review the files and prepare for circuit court. At that time, I was told, well, have you talked to counsel for the board yet? And I said, I have not recently, and I was advised to talk to counsel for the board and tried to reach counsel for the board and couldn't. I then, I think a day or two later, I think maybe it was the next day, received, at the courtesy of your current secretary, and I wish she was here back in February, I received a courtesy copy of this stipulation of dismissal that was an absolute shock to us. Here we are preparing to go to circuit court and try our case in circuit court where it should be, and where I would argue today it still should be, and we get word after the fact, yet again, that there's been a stipulation of dismissal between the parties. Well, certainly we were a party back on February 20th, 2013. I was here. I argued vigorously for hours.
But you didn't take it up with the circuit court. You never filed a complaint as to not being represented, it was
Did-
silence.
Didn't file a complaint. Again, we were prepared, and why wouldn't we at this point, Your Honor?
So
We're-
you're
we're-
asking me to change the ruling of the circuit court?
No, I'm asking you to dismiss this matter before you, because under the law and under, frankly, Your Honor, your own administrative decision, number one, that you've issued to the protestants in this matter, a record was created before this board on the same facts and the same issue, and a determination was made. Under the case law, I cited it in my memorandum, I'm glad to pull it out and reference again, the board does not have the authority on its own initiative to rehear this matter unless there's new facts.
The circuit court didn't dismiss it. They sent it back for reevaluation.
Based on a stipulation of dismissal, which I would argue under the law.
Yeah, but they said why. They said why.
Actually, all they did on the docket entries was enter the stipulation of dismissal. The parties said why.
Yeah.
A judge never heard this, Your Honor, unlike back in the first appeal, where a judge reviewed the record, determined there wasn't a sufficient record, and said, you know what, I, the court, I'm going to send this back to the board to create a record. When I finally did reach counsel for the board, I said, why are we doing this again? Why are we going back before the board? Didn't we just have a 3-hour hearing in February? And her statement to me was to create a record. We already have a record. And more importantly, the court above did not review that record. It merely entered a stipulation of dismissal between the parties, which did not include my clients or me, and the matter is back before you. The court above not having heard anything about the sufficiency of the record that was created on February 20th, which I would argue is more than sufficient, and the matter should remain in circuit court, Your Honor.
Multiple points to that, Your Honor. First, here is a copy of the order signed by Circuit Court Judge Pamela White, remanding the case back to you. Second, as co-counsel, or as my opposing counsel notes, the licensees did have notice of the appeal, and now they're claiming that they were ready to go to the circuit court, yet they never did file an appearance before that tribunal. Even more with regard to the opposing counsel's argument that somehow this claim is precluded by res judicata, they cite, I believe, 5 cases, all of which precede the 2 cases we cite, which hold that a agency of the state of Maryland may review errors of law. We are not asking you to relitigate the facts. This is strictly a legal argument in which we believe that estoppel cannot be held against a government agency.
That it?
No, sorry, I thought you had a question. Previous makeup of this board declared the license at issue valid under a theory of estoppel, even though, as that board confirmed, the license was expired under Article 2B. In the state of Maryland,
I think his only issue right now, before he argues his case, is the issue of the coming back the second time.
correct, and under Article 2B, Section 16-101, subsection E4, double I2, the circuit court may remand decisions back to the liquor board. Even more, under Maryland Rule 8-604D, it also holds that in the interest of justice, a case may be remanded.
I agree, and I think it is back again. And I can't read the judge's mind, and because I wasn't there, but this is a circuit court which has jurisdiction over the liquor board. So we're going to go on now with the hearing. Go ahead, sir.
Very well, Your Honor. I believe it's a petition on remand, and I'll defer to opposing counsel to present their case, and I'll respond accordingly.
That's right. Go ahead.
Okay. As I referenced before, a previous makeup of this board declared the license at issue valid under a theory of estoppel, even though, as the board had concluded, the license was expired under Article 2B, which governs the validity of the license. Under Maryland law, the government cannot be estopped under the same terms as other litigants.
I think the whole issue of estoppel, though, was simply a payment of the fees. I mean, that was, I couldn't understand really what the liquor board chairman was saying. It was very confusing, but that seems to be the basic reason. Isn't that correct?
That's correct, Your Honor. The license had expired, and after the license expired, employees of the liquor board exceeded their authority in accepting renewal payments for the license. However, that is not authorized under Article 2B. In fact, in 2001, Senator George Della attempted to submit to the legislature a law that would provide authority for the liquor board to do so under various circumstances. However, that did not pass in the legislature of Maryland. It is obviously not the law that the renewal fees could have been accepted, and therefore that does not stop the liquor board from declaring the license invalid as it would under Article 2B otherwise.
Did you know that Senator Dell is here today somewhere?
Yes, sir, and he is prepared to speak regarding the statute if you would like to hear.
Is he a witness for you or for the other, for whom?
He's a witness for us, yes, sir.
Do you have any other witnesses?
No.
Okay. Go ahead, sir.
So it is our position that under Article 2B, the license is expired and the government cannot be stopped. The Court of Appeals has held that on countless occasions. Two recent cases are Marzullo v. Khan, in which an individual received approval from the zoning board to construct a reptile barn on his property. I believe they approved that under zoning RC4, which was only for preserving watersheds. And with that, you were allowed as a matter of right to construct a single-family property. Obviously, a reptile barn was not within the purview of that statute. Eventually, they revoked the statute, saying that it was illegal, and the individual appealed that and claimed that the government was stopped from denying the validity of the license. The Court of Appeals held that the individual was charged with knowledge of what the zoning board could do, and therefore revoked that license. They said he could not rely on illegal acts of the government agency. In another case, ARA Health Services versus the Department of Public Safety and Correctional Services, the state erroneously had paid medical costs to the health services company for the payment of AIDS medication for inmates. Under the law, they were only allowed the money for hospitalized inmates and not those that weren't hospitalized. Therefore, in a future credit to the health services company, they withheld the money previously paid. The health services company said that we already relied on that money that you had provided us, therefore you're stopped from enforcing the law as written by the legislature. And the Court of Appeals again said that you are charged with knowledge of what the government agency is allowed to do, therefore you can't rely on their unauthorized acts. And that's precisely what we have here. The licensees kept paying their renewal payments even though the license was expired. They're now claiming that they relied on the acts of the liquor board in allowing those payments, and that the liquor board is now stopped from enforcing the law as written. Under Maryland law, that is not acceptable, and therefore we ask you to reverse the liquor board's previous decision and declare the license here invalid.
All right, now, first, before I go ask you to present your witnesses, I want to see if anybody has any questions.
I do.
Mm-hmm.
In one or two of the cases that you cited,
Yes, sir.
where government employees provided services that cost some money,
Yes, sir.
when they put a stop to that, were they given the money back that they lost in providing that service? In the case that you cited?
No, sir. The money was withheld from a future credit, and that's when the services company sued the government, when that money was withheld from a future reimbursement.
The government provided a service.
The government provided reimbursement to ARA Health Services, who provided medical treatment to inmates with AIDS.
And then the medical group that provided the service to the inmates sued the government for money.
Correct. The government had overpaid the health services company, the private company,
Okay.
and after they overpaid,
Okay. The government either made the healthcare company reimburse them, or either they held future money from going to them, so that the money that was spent would either come from money that they don't receive, or either the money was reimbursed back to the government. Is that correct? I want to make sure I'm clear. The government got their money back either by getting it back from the company, or by not giving them future funds and deducting that money from the future funds.
from deducting the money from future reimbursements.
All right, but they were made whole.
The government was made whole, yes.
All right, thank you.
Questions? Any?
No questions.
All right, call your witness, sir.
Morning.
Morning. Swear the witness.
Raise your right hand. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
And your name?
George Della, D-E-L-L-A, 405 East Hamburg Street, Baltimore, Maryland, 21230.
And for the benefit of others, you were a state senator.
For 28 years, served in the Maryland General
All
Assembly.
right, I'd be glad to hear from you.
46th district?
46, well, started out 47th district and then 46th district because of redistricting.
When you use the microphone, yes, sir.
Sir, pardon me. And let me narrow my comments to this one issue. I was the sponsor of the 180-day rule. I made it law. And it was done so for two reasons. Number one, the licensees that I represented in the district, they wanted it. Number two, the community groups, they wanted it because it absolutely made sense because of the number of liquor licenses that were in existence at the time. That was in 2000, that was passed and became law.
You say because of the number, explain that again.
Because of the great number of liquor licenses that existed in the city.
And how would this rule affect that?
Well, because I think the whole issue became or came to the surface because of the activities of a liquor license broker who was selling licenses and trying to transfer them into neighborhoods where there was already a great number of liquor licenses. Community groups opposed it, and he would in fact shelve those, not shelve them, but try to peddle those licenses into neighborhoods where they weren't wanted. They came from other areas of the city.
You're talking about licenses that were not in business, or what?
Not in business. Not in business. And because of that, a couple things happened. We built a wall around the district. Can't transfer anything into the 46th legislative district because of that. Then came along 180-day rule. And that is existing law in Baltimore County and was at the time, and that's exactly what this mirrors, Baltimore County law, 180-day rule. And it's really quite clear. The board, the administration at the time, Jane Schroeder and my former colleague, Senator Nathan Irby, then complained to me that it was causing them to lose license revenue. And would I please consider changing the law to allow the board to continue receiving that revenue because licenses were being killed. Well, because of my relationship with both of them, I said, all right, you send me the wording you want, I'll drop it into the legislature, which I did in 2001. Well, the feathers hit the
So
fan.
what was you going to tell us what the wording was, or it's not
Yes.
important?
First of all, here's a copy of Senate Bill 128. It is current law dealing with 180-day
Thank you.
rules.
Here are the extras.
I've got one extra, and I don't want to exclude anyone.
It's okay.
I'll give mine to,
There.
go ahead. I'll
I
come
think I
back.
kind of know what it is.
Then in 2001, at Jane and Nathan's request, I introduced
Give it one.
Senate Bill 138. And the meat of it would be, and here's a copy of that. And I'm sorry I
This
don't
is
have
the
enough
same
copies
as,
to give out.
Counsel, anytime you want to see it, please.
Thank you, Your Honor.
Here's the wording that I think the applicant is looking for relief. Notwithstanding any other provision of this section, if all license fees have been paid to date, the board may grant an extension to the period the license is deemed unexpired for a time that the board determines to be appropriate due to bankruptcy, fire, natural disaster, displacement by condemnation or other unusual circumstances, which would have opened the door to the 180-day rule. Well, the feathers hit the fan, because the licensees that I'd worked with, putting in place the 180-day rule, they were upset. The neighborhood groups were upset and came to me and says, what are you doing? You're undoing current law. Well, it was all because of the friendship that I had with Senator Irby and Jane Schroeder. And I went back to them and I said, look, folks, I understand you're having a revenue problem, but it's not going to be helped by this because I'm withdrawing the bill. I sent a letter to the committee asking them to withdraw the bill from their files and records, and the bill was given an unfavorable report. So what I'm saying is,
So let's go back, then, that left existing.
existing law.
180-day rule. Now, tell us what that bill's, that's your bill, you said,
Correct,
and it passed,
correct,
and that was in 2000.
correct.
And what does it say?
That basically says the license can remain dormant for 180 days. And then if there's a hardship, then that licensee can come back to the board and make their case that they're in a hardship situation, and the board could then grant them another extension of 180 days.
That's the ones on the books now.
Correct, that's current law.
Now, what limitations are there for extensions? Any?
None,
And can it be re-extended?
no.
And what happens to the license if it's not, if the person does not take advantage of the 180-day rule, or does take advantage of the 180-day rule, what's the effect on the license?
If they take advantage of it and the time is told 180 days or prior to the end of the 180 days, and they come before this board and plead their case, the board may or may not grant them another 180-day extension. Beyond that, if they don't activate that license is dead. That's what the legislative intent is behind the 180-day rule. And the board knew it. The board knew it. After this, after I withdrew this Senate Bill 138 in 2001, which would have relaxed the 180-day rule, I then went back and worked with both Nathan Irby, Senator Irby, and Jane Schroeder in helping them in addressing what they said their problem was, and that's increasing license fees. Because they claimed they didn't want to kill the licenses because they didn't want to lose the revenue.
Okay,
But
anything?
that doesn't, but the 180-day rule is a 180-day rule. I mean, it's actually a year if you come in and make your case to the board.
In other words, you say at the end of 180 days, one day before, during that period, if the license is dormant, they can apply for a 180-day hardship rule.
Correct.
And if the board grants it,
If the board grants it.
then that would give them a full year.
Correct.
At the end of that year, if the license is still dormant, what then?
That license is dead.
Anything else?
I think it's clear.
Questions?
I don't have any questions, Your Honor. I would just want to state for the record regarding the last statement by the witness that although a former member of the legislature, he's certainly entitled to testify as to the legislative intent, but it's Your Honor's job to interpret the laws to the matter in terms of what happens to the license after it's dormant. So I would just make that objection for the record.
All right, any further questions of your witness? No, Your Honor. Commissioner, questions?
I do have a question. Was there, in terms of the legislative intent, as this was being discussed, was there any discussion as to what constitutes hardship?
No.
So all an applicant or a licensee need to do is come in and say, we're experiencing some hardship, undefined, and they get that additional 180 days.
We don't have our act together. We're struggling here. We're, making improvements to this facility that's going to become a licensed liquor establishment.
Okay. And we're not talking about transfers now, but it's rare that we get this living legislative history and on the intent, and so I
I
wanted
could
to.
give you more.
I
I could give you the
kn-
whole of that Article 2B. I mean, it's one of the most boring, articles in the annotated code.
I would have agreed with
But,
you
but I
prior
can
to
give-
June 24 when I joined this
But
board.
I can give you a 28-year history of it.
I don't think we have time for a 28-year history, but in terms of transfers, we've been applying the 180-day hardship rule to transfers of licenses. Is that appropriate, or is that consistent with the legislative intent, or no?
You have applied,
The 180-day rule to transfers of licenses. So not just extending the life of a license, but when a licensee is attempting to transfer a license from one location to another, it's taken, in some instances, 2 years, 3 years. They've,
180-day rule should apply.
okay, all right.
Any questions of your witness? None. No other questions of the commissioners?
No.
You noticed you brought a huge thing in with you. Is that some kind of an exhibit, or you just carry it around for fun?
Judge, can I show it to you?
Sure.
I mean,
I'm afraid.
I mean, it's not exactly on point, but, it'll give you sort of a picture of why I was doing what I was doing, and why I know sort of
Okay,
all
well,
the nuances of Article 2B.
break our suspense, show it to us.
You'll have to excuse me because, and pardon the public. This is a map of what I used to represent, the 46th legislative district. And out of I think it was 1,390 liquor licenses at the time, we had almost half of them. Half the liquor licenses in Baltimore City. And over that period of time, Mr. Wallman, described a wall being built in the law around the establishments on Cross Street, 1st Precinct, 23rd Ward. Did the same thing over in Canton. That's the 5th and 6th Precinct of the 26th Ward. And I used to go around to neighborhood groups and show them what we were dealing with, because the number of liquor licenses and the size of these establishments affects the quality of life in neighborhoods. And much of the legislation that was passed, was based on dialogue between community groups and myself for 28 years. And whether it was the 300-foot rule from churches or schools, which I didn't dream up, Senator Verna Welcome dreamt that up with her district, whatever that may have been numbered at the time. We adopted that, and my colleagues adopted it citywide. But, it wasn't all anti-licensee. Introduced the first pub brewery license legislation for, Hugh Sisson. Good businessman on Cross Street, great establishment, neighborhood loved it. It's just, but it was things like that. 6-day licensees, they complained because they couldn't be open on Super Bowl Sunday, or, put a provision in the law where they come in and buy days, to stay open those, I think it's up to 4 days a year or something like that. And I forget what the fee is. But this is what we were dealing with. And that's why you have the 180-day rule in place. That's why, I tried to be fair-minded and open with everybody, licensees, community groups, and, and you might ask, why would licensees want the 180-day rule? Well, because you can only cut the pie up so many different ways. That's why they came to the table and bought into it. And like I say, I wasn't the genius who dreamt that up. It mirrors what they adhere to in the law in Baltimore County. That's where it came from.
Now, what was the effect of this 180-day rule with respect to density of licenses? Was there any effect from it or result from it?
Correct, there were, because the board initially killed licenses. I mean, they were deemed dead. If in fact they had been dormant for the 1 year period of time. I know that because I knew some of the licensees, and they were yelling, screaming, kicking, hollering. You know, why did you do that? It's because it's a law.
So the, to go back, if a person took advantage of the 180-day rule, on the last day of 180 days, they would get another 180 days.
Correct.
But at that time, if the license is still dormant, the license would expire. Is that correct or not?
Again,
I-
I would object
I-
for the record as to the legal conclusion from the witness, Your Honor.
I believe what the
That's
board.
absolutely correct.
I believe what the board was doing that, at that point in time, was being laxed in the application of the timing of the first hardship request and allowing people to come in, make their hardship case after the 180-day period, but it wouldn't toll from the time of that request. It would toll from the time of the initial 180 days, if you follow what I'm saying.
No, I don't. Explain it again.
Okay. If 180 days had expired and someone had not made a hardship request prior to the 180 days, the board would allow them to make a request after, but it would continue to toll from the initial beginning of the 180 days.
All right, anything else? Questions?
So what you're saying is, if I'm following you, if a licensee does not apply for the hardship extension within that 180 days, on 181, on the 181st day, that it's too late. The license is dead. Technically.
You're right.
And
Yeah.
certainly, if it's 365 days later, a whole year later, which has happened, I'm not saying that's this case, it's good and dead.
Right.
One of the arguments that we hear often is because large amounts of money have been spent in advancement of opening an establishment with a license that technically has expired, the board should take that into consideration. In other words, so much money has been spent, there have been large expenditures, sure, the time period has elapsed, disregard that and extend the license. Was that ever considered as a factor in the legislative process of bringing about the 180-day rule?
Yeah, when people are spending a ton of money on improving a place to open sometime in the future, I would imagine that they've hired some big shot lawyer to protect their interest, and they ought to be aware of what the law is.
So it's sort of assumption of the risk?
It is, I mean.
Again, I would object to the legal conclusion from the witness. Thank you.
Well, wait a second, he's not making legal conclusions, he's answering my questions. And I feel very fortunate to have this information, because it's something we deal with all the time. And I'm new to the board, and I would.
I'd come
yeah.
back at any time and sit with you in a non-hearing situation and give you a legislator's perspective on how things are done or how they should be done. And
As lawyers, we always want to know why something was done. We always want to know what
something
problem.
you might not want to know.
Well, I just want to know what problem was trying to be solved by this rule. And so therefore, what you're telling us today, this morning, is very, very, very helpful.
There's a
And I,
fine, you know, in all of what I said, I mean, there's a fine balance between the number of licensees and the interest of neighborhoods, because you want people to move in to the city, and which they've done. You want them to have nice restaurants, nice taverns within walking distance, because my God, when you get home If you live in one of these neighborhoods in Canton or in Federal Hill, you park your car if you can find a parking space, and you're locked in. And most of these young people, they've got cookless kitchens, so where are they every night? They're out finding a half-price burger or a, you know, cheap pizza.
And it's not just the young people, it's the older folk who take lunch or take dinner
I
at
understand.
Charles Village Pub.
I
So,
understand.
so the other question I have, you said that you sort of did a circle around Federal Hill and closed it off.
First precinct, 23rd Ward.
And the purpose was what?
To prevent the transfer or the creation of any new licenses into that precinct.
So, I was wondering, just.
And did the same thing over at Kent.
Okay. So, as I was thinking about this case and other cases in Federal Hill, if this license is found to have expired,
Correct.
what are the options for the licensees?
Buy another license from an existing location.
They can't,
And honest to goodness, I cannot remember the number of licensees in that precinct. That has sort of been lost in the back of my head.
in your chart, you had a lot of stars, and my
Right.
granddaughter would love that chart because she loves all those stickers. But did the different colors mean anything?
The different types of licensees,
Okay,
or licenses.
okay.
You know, whether they're 7-day licenses, 6-day licenses, packaged goods stores.
Okay, I think that's it for me. Thank you.
Any other questions?
I was going through it. I think I'll hold mine for now. Thank
Any
you, Senator.
questions?
No questions, I'd just like to be heard.
Any other questions? All right, thank you, sir.
Thank you for your time.
Thank you, Senator.
Be glad to hear from you.
Thank you, Your Honor, members of the board. Well, I certainly
Mr.
appreciate,
Rowley, he hasn't finished his presentation, but you're going to asking me for the privilege of rebutting at this time.
I'll reserve until after he's presented his case in chief. Thank you.
All right.
Thank you, Your Honor.
Your Honor, we are prepared to end our case in chief on the point that estoppel is not permitted against a government agency that exceeded its authority. Thank you.
First of all, Your Honor, with
Wait a
regard.
minute. Any questions?
No questions.
Go ahead.
First of all, Your Honor, with regard to estoppel, the majority of the case law cited by the protestants in the memorandum before you today talks about mistake. Where was a mistake ever made here? Where did we ever argue mistake? We argued there was a tolling of the 180-day rule, which is in the existing law, which was in the existing law that the former senator testified to. We've argued, for whatever reason, protestant mentioned in their memorandum, it was the first time that we've raised that issue. I'd like to quote from I understand Your Honor denied my motion to dismiss, but I would like to quote from the February 20th hearing, page 28 of the transcript. This is myself speaking at that time. The license has been renewed every year. It is very interesting if you look at FHNA's chart that each time the license is renewed, there's nothing listed in their chart regarding that in the third column. The reason for this is obviously they do not want to admit that the license renewal can certainly be construed as a tolling of the period under Article 2B. So I made it then. Page 31.
Let me interrupt you at this point and tell you that just from my reading that you were not taking advantage of the request for the 180-day rule, and you didn't use it. And these issues of granting extensions by the liquor board had nothing to do with the 180-day rule, and the tolling kept mounting up until finally he gets over 1,000 and some days, and you have not taken advantage of the rule at all.
And the reason we didn't take advantage of that rule, Your Honor, is there is a rule within the law, and I'm going to quote from the High Court of this state
So
from
you
last year.
you admit that you never did that.
We never filed for a 180-day hardship, but what we did do was renew the license every year, Your Honor. And with all due respect to the former
I understand
secretary,
that
the
you're-
reason for my objections to his legal conclusions is the High Court last year ruled on this issue, and there's a case that is directly on point regarding the renewal of the license every year.
Well, let me just
tolling period.
stop a minute, and let me just make sure we understand your point.
Certainly.
That you did not use the 180-day rule, but you're relying on the fact that the fees were paid.
We're
Is that what you're relying on?
No, we're relying on the fact that we renewed the license every year, and that under the law from
Through the
the
liquor
High...
board.
Through the liquor board. And under the
And
law...
You're referring to these occasional decisions by the liquor board.
No, I'm talking about the consistent, multi-year, routine renewal by this board, acceptance of fees by this board of my client's renewal for this license, one of which was protested in 2011, and the protest failed.
So I just want to repeat it, that you're not relying on the request to extend the license through the 180-day rule,
Not the 180, no.
but you're relying upon the payment of fees and the fact that this board acted renewing your license from time to time.
And most importantly, Your Honor, the fact that the 180-day rule has within it a provision that the 180-day rule is told if a transfer application is then pending. I argued back on February 20th. I argue again today, under the case law that I cited, that the board is given great deference in its interpretation of its statute. The board can certainly
That's where there's,
consider.
Yeah, but that's when there is a conflict that's reasonably, I mean, I'll be honest with you, I didn't think that applied here at all.
Very well, but what does apply, Your Honor, is the ruling from the High Court. Would you agree?
What is
When I'm ready to cite the,
Well,
would
you
you?
haven't cited it.
Okay,
Go ahead.
I will, thank you.
I don't want to interrupt your argument, but you have to understand that if we
I don't have an extra
commissioners
copy. I
don't
can show it to
understand
you.
what you're saying, you know, that
Perfectly
it's better to ask a
understood.
question.
Understood,
To
Your
try to
Honor.
understand what your position
And I
is.
appreciate that, Your Honor. Thank you. Just to finish my earlier point, I again argued tolling on page 31 of the transcript.
And you have
back
plenty
bef-
of time, so relax.
Well, that's fine. I just wanted to make the point that this was argued before, back on February 20th. I argue it again here now. What was not brought up on February 20th, and I do bring up now, and again, with all deference to the former senator, the reason for my objections to the legal conclusion, and I think it was a very good question that the commissioner asked, what happens after that total of 360 days expires and the license is dormant? What happens to the license? Well, the senator testified that it dies, that it's dead. And I respectfully disagree, and the Court of Appeals of Maryland, as of last year, respectfully disagrees. It's a case that's actually, you have a copy because you cited it in your memorandum. It's Yim LLC et al. V. M. Hazlett Tuzier. Correct, you're correct. It's Court of Special Appeals, second highest court in the state, and not overturned, by the way, after shepherdizing the case, Your Honor. The conclusion reached by the court in that case, and this is directly on point to this situation. There was a bar, a controversial bar. This is a restaurant, but a controversial bar in Charles Village named Two Sisters. And that license was deemed expired by the court. Not unlike this situation, and I'll read directly from the decision. The total time period for which the licensee could be deemed unexpired was thus 360 days from the cessation of alcoholic beverage businesses, or from April 30th, 2008 is the date that the court cited for the unexpired period of the license to have occurred, April 2008. The 360 days had run, the license could no longer be deemed unexpired. The court went on to state, however, I'm sorry, do you have a question?
Well, I was thinking you were going to give us the site. You said Yim LLC et al. Versus
211 Maryland Ave. 1, 63 Atlantic 2nd, 1078, 2013.
Okay, and it's Yim versus,
Versus M. Haslip, H-A-S-I-P, I guess it's Hasip, Tuzier, T-U-Z-E-E-R et al.
okay, thank you.
The court went on to state, after finding that the 360 days, which the senator was talking about, had ran, the period for which the license could be deemed unexpired was 360 days, thus April 30th, 2008. The court went on to rule. Two Sisters also filed an application for renewal of the liquor license in October of 2008. Now, this is where the facts differ. They didn't file the renewal until after the cessation of the unexpired period. My clients have been filing renewals consistently on a yearly basis since 2009. So I just want to make that distinction. Nevertheless, the court, Two Sisters, filed an application for renewal of the liquor license in October 2008. Although the exact date is unclear, the application was notarized October 21st, 2008. The board received it on or around October 31st, 2008. And by the way, the court does reference Section 10-504D, which is the law that the senator was testifying to. Section 10-301J permits the board to charge a fee of up to $1,500 or even reject a late application, but does not preclude the board from accepting applications more than 30 days after the March 31st deadline. Accordingly, the board was within its rights to accept Two Sisters' October 2008 renewal application. And here's the clincher. Two Sisters' liquor license thus survived beyond Two Sisters' business itself and lived on to be renewed or transferred. These are years of licenses, and I'll submit this as my exhibit number 1. Years of licenses from this board granted to my clients. I don't know if I'm a big shot lawyer like the senator said, but I would argue that I'm here to protect their rights because they followed the direction of the liquor board. They received a license each year. It was a renewal. The renewal tolls the 180-day period, and the Court of Special Appeals confirms that directly on point.
Exhibit 1, you want to see?
Okay.
Your Honor, opposing counsel did not cite that case.
Wait a minute, just a minute. Any questions before we go on?
I do have some questions about the case, but perhaps you will, I'll ask after you're done your presentation.
He did not cite it. He's merely citing a proposition that the license survived after the cessation of the business. Under Rule 10-504D, it does survive 180 days, potentially 360 if a hardship extension is granted. I did not have the opportunity to review this authority as he did not cite it and is essentially blindsiding us with it this morning, but I assume that's what the court is holding because the color of the law states that there's 180 days to... the license survives 180 days after the business closes or 360 if a hardship extension is granted, and the liquor board, under its authority, cannot accept renewal payments past that for an expired license. Essentially, it's an estoppel argument he's making.
Question. If indeed the liquor license is renewed, does that toll anything?
Not under the rule. Under Rule 10-504D, there are 3 situations in which the license, it can be tolled, and that is it's transferred, but a transfer must be completed within 180 days under Rule 10-503D4, whether there's a hardship extension granted or whether the licensee passed away, in which it can be tolled in that event as well. And other than the transfer here, none of those situations apply.
Hardship to the person who has that license. No one never informed them, not this case, but in the case, that this license isn't any good because because they're taking the money. They're taking the money, so that's an indication to me as a client, a liquor license person, that you're saying to me that my license is good. So help me to understand why, sitting over here, I will make a decision that will adversely affect that person standing over there.
Yes, sir, and that's the premise behind the Court of Appeals not allowing estoppel against the government. While you may be doing that individual a favor by upholding the actions that the liquor board take, you are also doing a disservice to the rest of the general public in not upholding the law as the legislator, their representatives, wrote.
Thank you.
Questions? Any?
Yes, I wanted to go back to the Two Sisters case, and I think I've got some familiarity with this. Is this the location was on Howard Street? And that's not as important as my next question, or a series of questions.
While you ask that question, I'll try to get an answer to your first question.
So my next question is, I wanted to get the timeline on the license in the Yim case. Because I do agree that the holding of that case is that a license can survive the cessation of business. That's not our issue here. That is not our issue here. All right, so that's a clear distinction in the facts. What will be important to me is to know whether or not the Court of Special Appeals specifically found that the license continued on and was essentially revived after its death by the acceptance of a fee.
And I completely agree with you, and the court absolutely answers your question.
And let's hear what they say.
I'll read it word for word. The total time period for which the license could be deemed unexpired was thus 360 days from the cessation of alcoholic beverage business, or, in this case, I'm adding that, from April 30th, 2008. So I will now make comments. What the court is saying, I'm just going to make sure everyone's clear on this sentence. The total time period for which the license could be deemed unexpired. In other words, the total time that they had under the 180-day rule was 360 days, and that's what they're saying. They had that, and that ran on April 30th, 2008. So while I would argue it's not dead, I would argue it's dormant, which is what the chairman the word the chairman used in the last hearing, this is what the court is saying. It's deemed unexpired up until that point, so therefore it's deemed expired, if you will, to take the actual language used by the court. In the next paragraph, the court found Two Sisters also filed an application for renewal of the liquor license in October of 2008. So the court has found, per your question, the license, to use your term, was dead in April of 2008. The court also found that a renewal application was filed in October 2008. Although the exact date is unclear, the application was notarized October 21st, 2008. The board received it in around October 31st, 2008. And Section 10301 permits the board to charge a fee of up to $1,500 or even reject the late application, but does not preclude the board from accepting applications more than 30 days after the March 31st deadline. Accordingly, the board was within its rights to accept Two Sisters' October 2008 renewal application. And then the final sentence, Two Sisters liquor license, and I think this answers your question. Two Sisters liquor license thus survived beyond Two Sisters' business itself and lived on after the April 2008 date, lived on to be renewed or transferred.
Again, if I may.
Yes?
April 2008 to October 2008 is 6 months, 180 days, which is permitted under the statute of which a business is not operating. This does not change the law as written. This case is within the purview of what Article 2B permits, and I apologize, I have not read the case recently, but judging from the expert that opposing counsel cites, that's exactly what the case holds.
Again,
Questions, anybody?
I guess it's unclear because if the Two Sisters license was effective until April 30, 2008, and they could apply for hardship beyond that, that gets you the 6 months and then the 6 more.
They couldn't.
Yeah.
The court found that the 360 days had already ran. There was no
So-
more hardship available, but was available was the renewal. And what's interesting, and counsel actually makes my point for me, what's interesting in this case is the renewal was accepted after the death of the license and prior to any other renewals. In this case, my client's been renewing this license since 2009.
The renewal was accepted after the business closed, not after the death of the license.
That's not what the court says.
That's what I'm struggling with. That's the point I'm struggling with.
Because the
'Cause
license
this-
may survive post-business.
And we know that. I mean, that's not debated, and it's not the issue here.
Then why are we here, most respectfully? I mean, if the license, if you're agreeing, if you're
We're here because a prior board made decisions that are not wholly consistent with the law. That's what I think. I know you think something different.
I certainly
you'd like
do, and
me
I
to
think,
think
and I
something
think that,
different,
and I,
but that's the sense I'm getting.
Yeah.
And, I'm new, so I take notes.
No,
I
no,
try
I-
to
no,
figure it out.
I appreciate
and
that, and
I
I-
did my own timeline, and it's just really concerning, the actions that were taken as well as the inactivity.
I would argue that there was activity, and that was the
Well-
that was the constant renewal of the license, and I would
Well,
respond
but
to your
even
question
beyond
about.
that, it's just a little, it's just not,
I understand.
not
I
as
understand
clear
your
as I
question.
think
I would
it
again
might
refer to
be.
the language of the court, which I think is fairly clear. I recognize that you're unclear at this juncture, but the language is fairly clear that the 360 days, which we've all and the senator argued, that's the maximum amount of time that you can take advantage of this hardship extension. It's 360 days. Well, the court found that had already ran, and that ran in April, and then in October.
Do you know whether cert was applied for in that case? Was cert denied?
Doesn't indicate that cert was applied, but I don't want to answer that absolutely without doing some more research. But I did research whether or not the case had negative treatment or was overturned. And again, I think
Has
it's
it
on.
been cited?
I believe it may have been cited, although I don't want to say something that's not correct. It was not overturned, it was not overruled, and once I realized that, and it was just last year that the court made this decision. But I think this decision, taken in conjunction with the statute itself, which calls for the tolling of the 180-day period, and then perhaps most importantly, the case law that allows the board to interpret its statute combined with this decision from the Court of Special Appeals, in my respectful opinion, leaves the board no choice but to find these licenses, including the current one, which is on the top of that pile, which is good through April of next year, are valid licenses. And the licensees who have invested significant time and money, as the senator points out, have certainly relied on those licenses. Why wouldn't they? This whole estoppel, I understand that previous chairman picked up on estoppel, and I agree with you, Your Honor. It's somewhat confusing as to his decision regarding estoppel, but it really isn't even an issue here. I mean, estoppel involves mistake, and all of the cases cited by counsel involve mistakes by staff, et cetera. There was no mistake here. A license was renewed every year.
So that's what gets me. I do think there was a mistake. I really do think there was a combination of mistake, judgment misapplied, benefit given. The Yim case doesn't go to the crux of the issue here, and the crux of the issue here is whether or not, as I'm hearing the arguments, whether or not mistake, error, I probably shouldn't go so far as to say wrongdoing by an administrative agency can be disregarded once it's been learned of. And the Yim case doesn't go to that.
Because the Yim case points out that this isn't a mistake. The Yim case points out that renewals.
But I wonder, it's not clear to me, and I wish I'd read the case before we got here. The Court of Special Appeals isn't going to go into territory that it's not asked to go into. And my question is whether or not the Court of Special Appeals was even given that issue, whether that issue was presented to the Court of Special Appeals to decide. But it is before us now. It is a question that we're being asked to decide, and that's what makes this complicated, if you will.
Again, respectfully, the only mistakes that have been alleged have been alleged by the protestants. We did not make that argument and try to argue estoppel in that fashion. And with regard to the case, I think it's moot as to whether or not that issue was presented, because the ruling is very clear on the 360 days having expired and then the license renewal being accepted. Obviously, we're going to agree to disagree, I'm missing where the language isn't clear in the case that after the unexpired period runs after 360 days, the board can accept a license renewal application. Therefore, it's not a mistake. The Court of Special Appeals says it's not a mistake, and that can survive the death, if you will. I don't like to use that word, but to use your word, the death of the license.
Well, it's not my word.
Well, I thought you said you thought it died, so that's the only reason I said that.
Well, but I only say died because that's what everybody in this room says when they talk about
Right.
the life of a license.
I know, zombie licenses and death.
Well, I think I got a B in civil procedure, and I don't.
Yeah, you
even
did better
think
than
I
me,
don't
so.
think I even took an appellate procedure course, but I do understand appellate law to the extent that I know that a court won't consider a question of law that it's not been asked to consider, and unless we can get information that shows that they were asked that specific question, I think the question remains open and undecided, and we need to now make that decision.
Just to answer your question on page 3 of the opinion, the neighbor's position was the license was dead. There's that word again. The neighbor's position was that the license was dead and not subject to a transfer because it automatically expired 180 days after two sisters ceased doing business in the property on May 30th, 2008.
And we know that's not true because they could have applied for a hardship extension.
But that was the neighbor. You're right. I'm not agreeing with the neighbor's position in the case either. But I believe that should help answer your question as to the issue before the court.
And I do some homework. This is why I say, this is all, it's not my original thinking to call a license dead.
I would just make one other statement.
I accept the language of others.
Understood. I would just make one other statement.
It seems to be a term that we all understand. I apologize.
Oh, I'm sorry.
Make sure we get a good record.
Okay, just so I'm clear.
If I may, just one final statement with regard to this entire theory and I believe law as it applies to this situation. If this board were to rule that, given these facts, this license could not have been renewed all these years, and my clients could not be moving forward with their development of several consolidated, dilapidated lots in the city, then it would be ruling that any developer anywhere in the city that, in development, I represent several developers, can take years. And I would argue that it perhaps may be or should be the board's policy that it's better to transfer an old license that is purchased rather than trying to go get new licenses, because I think overall in the city, the goal is to reduce the number of licenses, and I certainly understand that goal. If you rule this license invalid, that would mean a developer like my client, who's assembling properties and dealing with all the other real-world issues regarding real estate development, could not purchase a license from another location, renew it to preserve it after the they could use the 180-day rule, as Your Honor pointed out, but this goes beyond that. You can preserve it during, and I would argue that a lot of development takes more than a year, most of it does actually. You can preserve that license, and matter of fact, on the license itself, you can read it. It says contract purchaser, and that's often what's listed in development forms and applications. If you don't allow this license to be preserved in that fashion, how can redevelopment in parts of the city where I've got a client who's doing a large mixed-use project not far from here that wants to put a restaurant with a liquor license in it, and they're shopping right now for a liquor license. This project probably won't be finished for another 4 years. And they can preserve that license by renewing it each year.
An interesting point, but you're asking, of course, what would the liquor board do in view of an extension beyond beyond a 1-year period? And perhaps an estoppel situation might arise under that. But I understand what you're saying.
Thank you.
But I'm ready for decision.
I have one more point of rebuttal.
Go ahead, sir.
I just want to point out that the opposing counsel's argument at the end here is essentially something to be taken up with the legislature. The liquor board is a quasi-judicial body that derives its power from the legislator and cannot go beyond what the legislator gives them the power to do, which is included under Article 2B. Further, if we uphold the opposing counsel's suggestion that the license be deemed valid because renewal fees were accepted, we're essentially allowing members of the liquor board to rewrite the law, and whenever a license is dead, they can simply renew that license, therefore reviving it. That was not the intention of the legislature, and we ask that you reverse the previous decision.
Well, I think
Thank
the
you.
law is clear that what the legislature says, the legislature means. And I'm always interested when I see court opinions beginning to go way beyond what it says and trying to read other meanings into it, and including a Court of Appeals, Special Appeals decision, which has nothing to do with this case, on the definition of what a citizen is. I'll never forget that one. But anyway, let me go on. On the 23rd of July, 2009, the board approved an application and transfer of a license to 1218 East Cross Street. No hardship exception was ever requested. No transfer was ever completed. Article 2B, Section 504D, Baltimore City license expires, is the word that, not dead, but expires 180 days after the holder of that license has closed the business or has ceased active alcoholic beverage business operations unless hardships requested, pending, or approved. With respect to transfer, Article 2B, Section 10-503D, a transfer must be completed within 180 days. Of course, I'm quoting the legislature. If not complete within the time period, then the authorization lapses. The Attorney General's opinion that the 108-day statutory provisions is mandatory. It's clearly stated many times. June, I can't read the date, something 19, 2009, application to transfer ownership of the bar Turners to the new, this licensee, applicants, also the transfer or request for location change, 1204 East Cross Street to South Charles Street. The board on July 23rd, 2009 approved the application, and the transfer 180 days starts to click. 180 days goes to January 19th, 2010. Then Mr. Sam Daniels, who is a member of our staff here at that time, put in some kind of a hearing or a meeting, granted a extension until July 25th, 2010 for transfer to be complete. Nothing happened until September 16th, 2010. The board gave another 60 days to November 15th, 2010, and nothing happened. This is on your transcript that I read, page 21. Protest in April 2011, not successful. Another renewal, which again, transfer on page 21, nothing happened. On August 18th, 2011, the board granted another 60 days. That makes it 276 days, and nothing happened. It wasn't told, according to what I was reading. The new 60 days goes to October 17th, 2011. The staff writes a letter on February 28th, 2012. You haven't paid. They write a letter to the licensee. The license is going to expire. You better pay. They paid, and another renewal was given, and that's on transcript page 21. On May 2nd, 2012, the staff writes another letter, didn't pay the license fee, said the transfer was approved, supposed to be completed. You stated this process on July 2009. On transfer 22, it says the original location for the transfer was 1100 South Charles Street. The original LLC that was going to operate this restaurant was forfeited in its charter for failure to file some kind of property release. And this was on October 1st, 2012. It's one of those strange situations that's never explained later on in the record. The board granted another 60 days extension. Now we're at 395 days. No action. New date is January 14th, 2013. On February 2013, an application for transfer and expansion. The hearing was June 27, 2013, and the board denied the transfer. There was an appeal to the circuit court on validity issue. Board counsel said the board had not had a full discussion on the matter. It was a 5-hour hearing, and remanded and said that you have to have a result this month. And then here we are, says the board, on February 20th, 2014. The licensee had the license for 1,673 days and for 3 years with no tolling, or 1,146 days of no tolling. Now comes the issue of estoppel. Estoppel is argued at this point, and it really is, I think we all agree, it just doesn't make sense. I don't know what they're talking about. On transcript page 35, says the board says they're renewing the license absent protest. And my question is how? The license is valid, and then they raise the issue of res judicata, and then the board says that doesn't make sense. The board decision of the hearing on February 20th, 2014. They were pondering estoppel, said the board. Does the acceptance of renewal fees preclude us, said the board, from declaring this license invalid as of today, meaning February 20th, 2014? Did the licensees detrimentally rely on perhaps promises we made, said the board, by accepting the renewal fees? And quoting directly, to avoid injustice to the license is to declare the license viable as of today. And that was what the board's decision was. So basically, in order to avoid injustice, the board decides to renew the license. Thus, the board decided to balance the equities it determined existed without any factual findings, in total lack of regard to its binding laws. Then there is a legal memorandum filed by Mr. Woolman of res judicata, collateral estoppel, on his page 5, Court of Appeals, where substantial evidence is the court accords deference to the administrative agency in its sphere. And I find that there's really no conflict of facts or anything that this would apply here. Following the stipulation of dismissal and agreement for remand from the Circuit Court of Baltimore City, the licensees finally filed a request for a hardship extension. This board stayed the motion until the issue of the validity of the license is resolved. On September 4th, 2014, I ruled that the issues, both the validity of the license and the hardship extension, should be consolidated and heard today. And here we are. The Miller versus State, 174, 362, a 1938 case is quoted. Article 2B, Section 101B, 3, quoted saying, quote, "The powers granted," and I'm directly quoting, but leaving out certain words, "the powers granted may not be construed to grant powers not otherwise granted," end of quote. So the code says it expires in 100 days after closure or ceased activity. The transfer must be completed in 180 days, the Attorney General's decision. Again, the word shall means mandatory in Maryland. Express direction given by the legislature regarding the privileges, not right, of dispensing alcohol. The citizens are charged with knowledge of the law, and certainly the lawyers. Here in this case, there is nothing ambiguous of the facts. The clear command of the law is ignored, and on page 12, the action by the administrative agency, the Liquor Board, outside the scope of its authority, may not form the basis for equitable estoppel. Article 2B, the 180-day rule, within which a party must complete a transfer, is told only upon death, is pending, or it is filed within the 180-day period. Thus, acceptance of renewal does not toll the 180-day time period. The legislature in 2001, which was quoted in argument, considered giving the Liquor Board the power to grant extensions of license fees if are paid. Was not passed. That was Senate Bill 138, 2001. A government body cannot be stopped from enforcing the law by unauthorized actions of government employees. And again, the case of 366 Maryland 158 of 2001 was quoted. The licensee argues they weren't notified of the appeal. And I mentioned the council points out that 10 days after the decision was docketed in the circuit court, a letter dated April 9th, 2014, counsel for the licensees wrote Fogelman, the chairman of the Liquor Board at that time, and acknowledged that the Federal Hill Neighborhood Association had filed an appeal in the circuit court. This matter is now before this board on the remand from the Circuit Court of Baltimore City for further consideration. Prior illegal, incorrect, inexplicable decisions place a duty upon an administrative agency to correct. Section D of Rule 8-604 allows a remand for further proceedings in the interest of justice, nor should the Liquor Board try to correct mistakes, omissions, failures to act of the licensees by examining what is best for the licensee. The sale of liquor is a privilege, not a right. The license has expired for all the reasons stated above. My fellow commissioners, your positions.
I agree with Chairman Ward, and really for all of the reasons stated, and I can't state them any better or any more clearly.
I asked a few questions during this hearing and trying to get some clarity on the subject matter. And it's easy for us to sit here today and say, well, the last board, we can't justify our decisions by the last board. We as a body are charged with reviewing the law, listening to the information coming before us, and then making a sound decision. And that decision may differ from the last board. And sometimes presentation before the new board is slightly different from the presentation of the last board. My decision. I think that this case is one that is bigger than this body here. I think this case is one that should be before the circuit court, although it was remanded back to us. I don't agree that we as an agency did all the things we needed to do to convey to the licensee that you are responsible for whatever they were responsible for. We didn't make that clear to them. Yes, they do have a right to know the law that governs the business that they operate. Yes, if they don't, they should have some legal authority that they can go to get this information. But in real life, it doesn't happen that way. And I know we have laws to govern how we live and interact. And I always say we need to deal with the intent of the law. And sometimes the intent is sometimes lost when you read the law. And we all have comprehension. We all can interpret things, but we don't always interpret the same thing. We have two learned lawyers before us, and neither can agree. We have 3 judges here. 2 of the judges say no. I say yes, that the license is dead, and I'm saying no. I think a second chance is needed.
Just to clarify the no's, we both voted no, and you're voting
Yes.
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 Okay. Gentlemen, you have our decision.
Can I wouldn't be myself if I didn't respond to that. I just want to say, I do think that licensees are charged with understanding the law of liquor licenses, and they all have the opportunity to retain counsel if they wish. It's not required. In this case, the licensees have able counsel. They have a very, very good attorney. The size of the filings alone would attest to that. And I think that they've been well represented by counsel, irrespective of anything that the board did or didn't do, the previous board. They have an attorney who could advise them every step of the way. And I have to believe that the licensee's attorney informed them of the challenges that this case presents. I clearly agree with Judge Ward, Chairman Ward on this, and I don't want to go back over all of that, but this is not a case of confusion or lack of very, very good legal counsel for the licensee. There's no mystery here.
Folks, we'll stand in recess till 1:30.
Take care.
Mr. Woolman, I'm Fern from the Baltimore Brew, and I wondered what you want to say as far as appealing this decision, or what your thought is. No comment? All right.
I think we need to have a
We need somebody to come in and talk to us because we need to this is now the case. I'm telling you that, because I'm almost I hear you. So, I need a.
Oh, geez, she better not come back. What's this?
I need to tell you ASAP. What day will work for you for the
Oh,
deputy?
I could do Wednesday.
Oh, I'll do that. Okay, for now. Yeah, I'll try that. Oh, no, I can do it. It's the Breeze Black.
She's on the zoning board.
I'll fix that. I can do that. I can do that.
Yeah, the whole building was.
She's a good friend.
Jay, I would.
Rice to Town Road. This is a Class BD7, beer, wine, and liquor. A violation of 4.01A, minors. No licensee shall sell or furnish beverages to any person under 21 years of age, or to any person with the knowledge that such person is purchasing or applying beverages for consumption by any person 21 years of age. This was on September 2nd, 2014. Alcohol was sold to an underage police cadet.
Swear the witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
It's cold today, yeah.
All right, officer, identify yourself
Detective Archibald from Baltimore City Vice Unit.
and your evidence.
On September 2nd, 2014, at around 11:25 p.m., myself, along with members of the Baltimore City Vice Unit, initiated an underage alcohol buy investigation at Pepper's Liquor. This is located at 5440 Ricerstown Road. Utilizing a Baltimore City cadet, Emily Nasser. I observed Cadet Nasser, who is under the age of 21, enter the location via the main door. Cadet Nasser ordered a bottle of Seagram's Peach Twisted Gin, an alcoholic beverage from the store clerk, Young Kung Kim. Cadet Nasser paid for the alcoholic beverage, which was priced at $6.53, with a previously marked $20 bill. Mr. Kim accepted the $20 bill and gave the change back to Cadet Nasser. At no time did Mr. Kim request proof of age from Cadet Nasser during the buy investigation. Cadet Nasser walked out of the liquor store with a black plastic bag in her hand and notified members of the Baltimore City Vice Squad of the alcohol violation. I identified the contents of the black plastic bag as a bottle of Seagram's Peach Twisted Gin, an alcoholic beverage. Moments later, members of the Baltimore City Vice Unit, which consisted of Sergeant Detective Leiser, Detective Gatto, and myself, entered Pepper's Liquors, located at 5440 Ricerstown Road, and advised Mr. Kim that he just sold an alcoholic beverage to a person who was under the age of 21. Cadet Nasser was photographed with the purchased alcohol. I retrieved the departmental $20 bill from the store register, and the change of the purchased alcohol was returned back to the store. All events occurred in Baltimore City, state of Maryland.
Any questions, sir? Any questions, counsel, commissioners?
Yes, what is the date of birth of the officer? Or
Date of birth of the cadet.
cadet?
The date of birth of the cadet is 6/2/1994. He was under 21 at the time.
Okay, on the date of, okay, thank you.
All right, any other witnesses?
Just the cadet.
Come up, ma'am. State your name
My name is Cadet Emily Isaac.
and your assignment.
Is
Baltimore City Police Department?
yes, Baltimore City.
Assigned to?
Central Records.
All right, and your testimony with respect to September 2nd, 2014 at 5440 Ricerstown Road is what? That you,
Went into the establishment and used a departmental $20 bill to purchase the alcohol.
and did you get the alcohol? And then what did you do with it after you got it?
I walked out of the liquor store and showed the detectives, and they went in.
All right, any questions, sir?
No, sir.
All right. Any other witnesses?
No, sir.
All right. I find that you're responsible for the, no, but strike that. Your testimony, sir. Would you like to testify?
Well, I heard about.
Your name is?
Well, my name is Juan Yeo. I'm the owner.
And that's Y-E-O?
Yes, sir.
Yes, and you're the owner. And what do you have to say about this?
Well, anyway, it's not for, but my one of our employer is kind of like a tire and he's like.
Now, you have a previous happening of this, is that right?
No, I wasn't there, because I
But
heard.
your bar wasn't?
Yeah, I heard like the next day.
But I mean, in
my brother
December
told-
2013, were you found responsible for this board for the
Yeah.
selling underage?
Mhm.
Yes. And that's it? That's the only time?
Yeah.
All right. And what have you done to correct this?
Well, I told them, just tell them, every day, when they work, just, check the ID, so, and then I put the, the big, poster like, magic mark, red, like check ID, every
Okay.
day. And then, well, he's working like almost on just 1 year. And then, I don't know, I'm trying to fire him because, it's, for me, like, I don't know, I'm never, well, myself, I never happened like this before, since almost 20 years. But everybody like yeah, with my family, though. It was Bryce, used to be.
All right, sir. Any questions, commissioners?
No questions.
None.
I'm ready for decision. Anything else you want to say, sir? All right, responsibility, I find that you have violated the law with respect to sale to a minor, $750 fine in view of your 20 years, although you have a past record. And plus cost, how much time do you need to pay it?
Well, I can write down check today.
Today?
Yes.
All right, votes for my fellow commissioners?
I agree.
I agree.
All right, sir, you have our decision, $750 fine plus cost. Thank you. All right, call the next case.
Yes, sir.
Sorry, 2 seconds. The next case is Louis George, 2 Louis Cantina, trade name Punto G, restaurant and bar. This is at 123 North Clinton. This is a BD7, beer, wine, and liquor license, a violation of 401A, sale to minors. No licensee shall furnish alcoholic beverage to a person under 21 years of age or to any person with the knowledge that such person is purchasing or acquiring such legal beverages for the consumption of a person under 21 years of age. This occurred on September 2nd, 2014. Alcohol was sold to an underage police cadet.
For the record, Melvin J. Kanensky, 19 East Fayette Street, representing the licensee. Mr. Chairman, this would be an admission, and waive the reading. I would accept the police report as stated as part of the evidence. Quite frankly, we thought this was combined with the case from last week, but it wasn't. It doesn't.
Let me ask you about that, because you were here last week.
Yeah.
Now, why was it not? Why was it not put together?
I don't know. I didn't.
Because we received these, I think, like, right at the same time as the other charges, so these were separately sent by the police. This was in a packet for all of the September charges.
And your client suffered a 30-day closure?
That's correct, Your Honor.
Okay. Did you appeal that?
We did, but the stay was denied today, so we don't know where it's going to end up from there. But he's since instructed all his employees, and they're going to take the alcohol awareness course to check everybody, no matter who they are.
All right. Although you've admitted it, I want to still get the facts in the record of the police report. So give us a brief summary of what happened.
Yes, sir. From the police report, this was located. This happened on September 2nd, 2014. Alcohol was sold to an underage cadet with Cadet Nesser, who was present here. Detective Akawande was also there, and a departmental $20 bill was used to purchase those alcoholic beverages.
Any additions or corrections? You satisfied with those facts? And your officer, swear all the witnesses, please.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
And Officer Akawinde, are you satisfied with those facts?
I am, Mr. Chairman.
Okay. Anything else, any questions of commissioners or anything else?
I just want to confirm that the cadet's birth date is June 2, 1994.
That is correct.
Okay, thank you.
All right. Responsibility has been admitted, therefore the finding is the same, that you are responsible for the charge. In view of the fact that you were here before us and that the closure was instituted, I'm going to reduce the fine, even though you have a record for other things, to $500 plus costs. How much time do you need to pay it?
30. He's got the other fine. 30 days would be.
30 days. Fellow commissioners, your vote?
I agree.
Thank you very
You
much.
have our decision.
Thank you, Your Honor.
I call the next case.
The next one is Raymond Guskotoska. That is Spirit West, Inc., trade name Spirit West. This is located at 2601 Wilkins Avenue. This is a BD7, beer, wine, and liquor, a violation of 401A, sale to minors. No licensee shall furnish alcoholic beverages to any person under 21 years of age or to any person with the knowledge that such person is purchasing or acquiring such beverage for the consumption of someone under 21 years of age. This is again on September 2nd, 2014. Alcohol was sold to a police cadet.
Your name, sir? And you're not counsel? You're not a lawyer? No. All right, swear all witnesses, please.
Raise your right hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Gokuska, what is your plea?
We were guilty in doing it, but it's a freak accident. I've been there 33 years. And
All right, so hang on just 1 minute, sir. Also, give us your name, please.
Detective Akiwani from Baltimore City Vice Unit.
And what happened?
On September 2nd, 2014, at approximately 21:45 hours, Detective Sergeant Lisha, Detective Akiwande, and Detective Gatto were utilizing a Baltimore City cadet, Emily Nasser, in an underage alcohol purchase investigation. We responded to 2601 Wilkins Avenue, which is known as Spirits Liquor. Cadet Nasser, who was under the age of 21, entered the aforementioned location and asked for a Coors Light alcoholic drink from the employee, Nicole Jerrigan. Cadet Nasser paid for the drink with which was $3. Nicole Jerrigan accepted the departmental $20 bill and returned the change back to Cadet Nasser, along with the bottle of Coors Light. Cadet Nasser then notified the detective Gatto of the purchase in the establishment. At no time did Nicole Jerrigan request proof of age from Cadet Nasser during the buy investigation. Furthermore, Detective Gatto observed Cadet Nasser enter the establishment with nothing in hand. Moments later, members of the SES Vice Unit entered 2601 Wilkins Avenue, which is known as Spirits West, and identified Nicole Jerrigan. We advised her that she had just sold an alcoholic beverage to a person who was under the age of 21. Cadet Nasser was photographed with the purchased alcoholic beverage. Sergeant Lisha received the departmental $20 bill, and the change was returned back to Nicole Jerrigan. The purchased drink was left with the establishment. The establishment was left under the control of the licensee.
Mr. Gokuska, you want to ask him any questions?
no, it was just a freak accident. And what happened because she looks like a little girl lives up the street, and the girl served her.
The little girl that lived
Yeah,
up the street?
not a little girl. She's 22, 23 years old. That lives up the street from my place.
Did you actually make the service? Were you the person?
No, I didn't serve it. No, I was sitting at the end.
Just confirming the date of the cadet, it was not in the filing. What is the cadet's birth date? Just confirm that it's June 2, 1994? Yes, okay.
That's correct.
Alrighty, thank you.
All right, come over, ma'am. State your name for the record.
Yes, sir. My name is Cadet Emily Nizer.
And you've already been sworn. And do you confirm the testimony of Officer Alkawandi?
Yes, sir.
Any questions, sir? Do you want to ask her? Commissioners, questions?
No questions.
All right. Do you want to say anything, sir, before I find?
It was just a freak accident. I've been there 33 years in business there,
And you have no record?
And I have no record. No.
All right. I'm ready for any other questions, commissioners.
None.
No questions.
I find him responsible. $500 plus cost. How much time do you need to pay the fine?
Pay it today.
Today?
Yeah.
All right, sir. Commissioners, your verdicts?
I agree.
You have our record, sir.
I do have.
I mean, our decision, excuse me.
I don't have a decision. I don't have a record.
All right, call next case.
The next case is Jose Morales, Arizona Bar and Grill, Inc. This is trade name Arizona Spirits, Arizona Bar and Grill. This is at 25 South Broadway. This is a Class D, beer, wine, and liquor. It's a violation of Rule 401A, sale to minors. No licensee shall sell or furnish alcoholic beverages to anyone under the age of 21 years or acquire such beverages for a person under under 21 years of age. This is on September 3rd, 2014. Alcoholic beverages were sold to a police cadet. Also, a violation of Rule 3.02, cooperation. Licensee shall cooperate with with representatives of the board, members of the police department, health department, building engineers, office of the grand jury, and other representatives of government agencies whenever such persons are on official business. Again, this is on September 3rd, 2014. The bar manager became argumentative with police officers.
For the record, Melvin J. Kaminsky, 19 Space, representing licensee. It would be admission as to the 401A.
They must have been
violation
caught together.
and, not as to the other one.
All right, now, off the record, I have a question, not to you. What happened to the case of 5139 Park Heights Avenue?
I'm sorry, I just skipped over that one. It must have got stuck on my
We
thing.
got to go back to it.
I can go back to that,
Okay.
since I read this one into the record.
All right, Mr. Kaminsky, you've admitted the...
Excuse me,
report.
Judge, are you back on record now?
Oh, yeah.
Yes.
In the Arizona case?
In the Arizona
In the
case.
Arizona case. Thank you.
Sorry about that.
Made admission at 401A.
All right, but with respect to 302 cooperation, not admitted, is that correct?
Here's some testimony on that, if I can.
All right. I swear all witnesses.
Raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? I do.
All right, read the facts with respect to 401, the minor charge, into the record.
Yes,
We have
sir.
an admission on that.
Yes, sir. This was on September 3rd, 2014, at 12:30 a.m. The cadet entered the bar and purchased a Coors Light beer for $3. She used a $20 bill marked by the police department. She was was served that. She went outside. Police officers came in, informed the owner that she had purchased a bill, and purchased an alcoholic beverage, and she's underage. And her date of birth is June 2nd, 1994.
Now, Officer Alkawandi, is that your, would that be your testimony?
Yes, Mr. Chairman.
All right. Come over, ma'am. Would that be your testimony? Is this an admission in this fact?
Yes, sir.
Your name?
Cadet Emily Nicer.
Any questions of the commissioners?
None.
Any questions of council? All right, now with respect,
Okay, thank you.
with respect to 302 cooperation, you denied that. Now, hear from Officer Alkawandi, you've been sworn, is that correct?
Yes, Mr. Chairman.
And with respect to 302 cooperation, let's hear your testimony.
On September 3rd, 2014, at 12:30 a.m., myself, along with members of the Baltimore City Vice Unit, initiated an underage alcohol buy investigation at Arizona Bar and Grill, located at 25 South Broadway. Utilizing a Baltimore City cadet, Emily Nicer, observed Cadet Nicer, who was under the age of 21, entering the location unimpeded by the front door security. Cadet Nicer advised this officer that once inside, she sat on the bar and ordered a bottle of Coors Light beer, an alcoholic beverage from the bartender, Desi Rivera. Cadet Nicer paid for the alcoholic beverage, which was priced at $3, with a previously marked $20 bill. Mrs. Rivera accepted the $20 bill and gave change back to Cadet Nicer. At no time did Ms. Rivera request proof of age from Cadet Nicer during the buy investigation. Cadet Nicer notified members of the SES Vice Squad, including myself, of the liquor board violation. Moments later, members of the Baltimore City Vice Unit, which included Sergeant Lisha, Detective Gatto, and myself, entered Arizona Bar and Grill located at 25 South Broadway. Upon entering, I observed Cadet Nicer seated at the bar with an open bottle of Coors Light beer in front of her. I retrieved the bottle and advised Mrs. Rivera that she had just sold an alcoholic beverage to a person who was under the age of 21, which was Cadet Nicer. While trying to gather necessary information to the case, the bar manager, Mr. Franklin Garcia, walked up to us and became argumentative.
How does he spell his last name?
G-A-R-C-I-A.
Okay, go ahead.
Walked up to us and became argumentative and distracting, arguing the fact that Cadet Nicer was used as a decoy to confuse his bartender. Okay, the NISO was photographed with the purchased alcoholic beverage. I recovered the departmental $20 bill from the store register. The change and purchased alcohol was returned back to the establishment.
But did he use those words, used as a decoy?
Yes, sir.
Those
Yes,
are
Mr.
exact
Chairman.
words.
Among other things, yes, Mr. Chairman.
What are the other things?
He said that we were the bad guys and
Said
that
what?
he said that our squad, our unit trying to effect this investigation were the bad guys and that
Use the word bad guy?
yes, Mr. Chairman, quote
What do you
unquote.
mean by, well, I won't ask you what you mean. It means what it says. Go ahead.
And when I asked him for his ID, he did not want to give me his identification. He said he didn't need his identification to drive. He lives around the corner. So I identified him by getting his information. I believe he did have his ID on him. He just did not want to produce it because he wasn't trying to be cooperative. He also gave us a hard time with getting the bartender's identification.
Did he do that eventually?
We got the information eventually, yes, Mr. Chairman.
But not through him?
No, Mr. Chairman. We had to pull the bartender to the side to actually get her information.
All right, any questions, sir?
Yeah, and all this thing that you're mentioning now, none of that's in your report.
That is correct.
Okay. And along when you first came in there and you talked to the bar person, the bartender, you didn't have any problem with her, did you?
No, I did not.
Okay. And where was he when you came in? Was he right alongside of her, or was he in another part of the building?
He was by the side of the bar on the outside of the bar.
Okay. And then in between there, he was argumentative, as you said, because he thought that you were using the cadet as a decoy. Is that correct?
Amongst other things, yes.
Okay. But I mean, then I'm reading from what you said in your report. But eventually you identified him as the bar manager.
He identified himself as
Okay.
the bar manager.
All right. And then as a result of that, though, you got all your information you needed and you left. Is that correct?
Eventually.
You retrieved your $20?
Eventually, yes.
Okay. And then did you take pictures while you were there?
Yes, I did.
And they were cooperative? You took your pictures?
I took pictures that would needed to be taken.
Yeah, inside the place.
Yes.
Okay, no problem.
Commissioners, questions? None?
Well, I guess, why didn't you include all of that additional detail in your report about the lack of cooperation?
At the time, the only information that I put into the report was what I thought was, I summed it up.
Okay.
Because I was there for mainly the cadet buy. I wanted to finish up the report and keep it to the facts.
All
As
right.
opposed to fluff it.
Okay, thank you.
All right, Officer Alcalde, do you have any other evidence that you wish to present at this time concerning that charge?
No.
All right. Any evidence, sir, on your behalf?
No, just argument.
Okay. Commissioners, any other questions before we get to argument?
None.
I'd be glad to hear from you.
With regard to the cooperation clause, I think.
Who is with you today?
This is Morales, Jose Morales.
So this is not the person who gave you a hard time. This is the
No,
licensee.
he's licensee, been there for the last 11 years.
Mhm.
You know, if you read what as I was reading in the police report, there was no indication of this other evidence in there other than the manager became argumentative and distracting, that he thought that they were using this as a setup. It wasn't that he wasn't cooperating, it was that he was, you know, he had a difference of opinion. And I think he was okay to voice that. The question is how you view it in a way of cooperation. I think at the end result is that they did get everything they were supposed to get. They got their money back, they got their pictures, and they got the charges. So, you know, we would argue that that doesn't meet the criteria under the section of the code under 3.02, especially as to the fact of the definition of licensee.
What I find that he has not met the definition of cooperation and therefore is responsible for it. So we go to the issue of penalty. Now, I wanted to ask you some questions concerning this. I see here that Rule 312, public welfare, you have been found responsible for assaulting Liquor Inspector Jeff Ray, or somebody was, on September 26th.
That was that was in that report, the previous date, which is listed on here. So that is part of the previous charges from March 17th, 2011, Mr.
Okay,
Kadinsky.
and also on 3.03A, you were found
That's all, that's this one.
responsible for. The manager unable to produce purchase records. And 4.05A, you were found responsible, not B, that was dismissed. But A was consuming after hours, responsible. And 3.0 through C, you found responsible for unable to produce employee records. Now, what you have to say about all that?
What was the dates on that? Was that 11?
That was in 2011, yes.
2011, oh. Those weren't things that I had handled. I think some other attorney handled them. I think since that time, they hadn't run across those same problems with disturbing the community. I think at the time, Mr. Morales had a series of people who were managers that weren't quite up to snuff, but since then he has, and I've talked to him, he's going to have all his personnel take the alcohol awareness courses and to challenge anybody to make sure they have their ID. And also he admonished the manager that he is to fully cooperate even if he has a difference of opinion with the police officers.
Well, he's been there 11 years.
11 years.
Yeah. And this was 2011, so he was owner at that time.
That's correct. I don't know the details of that other than what you're reading.
What, does he want to testify or tell us, or not? It's your counsel, you decide.
Do you know what happened in 2011?
And he's been sworn, is that correct? He's been
Okay,
sworn?
yeah. Get up and give your name and address, because they don't hear you.
You've been sworn, Ms. Morales?
State your name and address.
And you are the licensee?
Yes, sir.
And what, if anything, do you want to tell us about your past problems?
The past problems, we addressed those problems on the manner, we had to change the managers, get rid of them, because there's one of the things, they're not working right, the way they was handling the place. That was what we did before in 1911, in 2011, I'm sorry. And now, basically, we have sometime, since we changed the manager that I was there, we had had no problems until now that this happened. I may say, I don't know how she passed the doorman because we have a security at the door. I don't know how this lady passed the doorman, but when she got to the bartender, I'm sorry that she served without asking for an ID. I don't know. I was not there. I just left like 11 o'clock that
All right,
night.
since September 3rd, 2014, for this charge of the minor and the cooperation, back to 2011, you have had no charges. Is that correct?
No, sir, not that I recall of.
Counsel, is that correct?
No, as far as I know, the ones that case on.
Okay. And you say you have different staff now?
Yes, sir, I do.
All right. Commissioners, any questions?
I don't have any questions.
No.
All right, I'm ready for decision. Anything else?
Nothing else for you to submit.
All right, in view of your statements with respect to, which I accept, that the record seems to indicate you've had a previous charge, therefore with respect to the minor, 1,000, and with respect to no cooperation, 1,000 consecutive, which means $2,000. But I'm not going to close you. But it's a warning, sir, with your background that you have. If I hadn't had your testimony through counsel with respect to cleaning up the situation, I would have been inclined to close your bar as a reminder of that your position as a liquor dispenser is a privilege and not a right. And therefore, 1,000 and 1,000, how much time do you need to pay it?
Until Monday.
10 days?
10 days, I think.
Or 1,000, 1,000. Commissioners?
I'm sorry, get that fine again. 1,000?
1,000 and 1,000.
That's
$2,000.
Plus cost?
Plus cost.
Okay.
But, and 10 days to pay.
So we're finding responsibility on both
On,
of
yes,
the
thank you.
violations? Okay.
Responsibility on both charges.
All right.
And 10 days to pay.
And, okay, I agree with that,
I
that
agree
decision.
also.
All right, you have our decision, sir.
Thank you.
All right, let's go back a case.
Yes, sir. It's Se Young O, Sume O, and Mi Young Nam. This is SSMO Inc. Trade name Nice Liquor. This is at 5139 through 41 Park Heights Avenue. This is a Class BD7. This is a violation of 401A. No licensee shall sell or furnish alcoholic beverages to anyone under 21 years of age with the knowledge that such person is purchasing or acquiring such beverages for the consumption by any person under the age of 21 years of age. This is regarding a September 2nd of 2014 alcoholic beverages were sold to a minor police cadet.
Swear all witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, you are who? Which one? O.H., your last name? And you are the licensee? Yes. All right. And you're not a lawyer? I'll be glad to, you've been sworn, and I'll be glad to hear, and let's just strike that. And I'll hear now from the first witness for the prosecution. State your name, sir.
Detective Akiwande from the Baltimore City Vice Unit.
And your testimony with respect to 5139 Park Heights on the 2nd of September 2014 is?
On September 2nd, at approximately 2300 hours, Sergeant Detective Leisha, Detective Akiwande, and Detective Gatto were utilizing a Baltimore police cadet, Emily Nizer, in an underage alcohol purchase investigation. We responded to 5139 Park Heights Avenue, which is known as Knight's Liquors. Cadet Nizer, who is under the age of 21, entered the aforementioned location and asked for a Seagram's alcoholic drink from the licensee, Mr. C. Young Ho. Cadet Nizer paid for the drink, which was $3.75. C. Young Ho accepted the departmental $20 bill and returned change back to Cadet Nizer, along with the bottles of Seagram's alcohol. Cadet Nizer then notified your writer of the purchase in the establishment. At no time did C. Young Ho request proof of age from Cadet Nizer during the buy investigation. Furthermore, your writer observed Cadet Nizer enter the establishment with nothing in hand. Moments later, members of the SES, Baltimore City SES Vice Unit entered 5139 Park Heights Avenue, which is known as Knight's Liquors, and identified C. Young Ho as the store owner. We advised him that he had just sold an alcoholic beverage to a person under the age of 21. Cadet Nizer was photographed with the purchased alcoholic beverage. Sergeant Leisha retrieved the departmental $20 bill, and change was returned back to C. Young Ho. The purchased drink was left at the establishment. The establishment was left under the control of the licensee. All events occurred in Baltimore City, state of Maryland.
Any questions you want to ask him? Commissioners?
No questions.
All right, officer, will you mind coming over? State your name for the record.
My name is Cadet Emily Nizer.
And your testimony with respect to this is what?
Basically what he said, I went in and purchased the Seagrams and with the $20 bill, and I walked out to show the detectives, and they came in and told them that they had purchased to an underage police cadet.
All right, and I'm going to anticipate my fellow commissioners' questions. And what is your age?
I'm 20 years old. My date of birth is 6/2/94.
And do you want to ask her any questions?
No, sir.
Any commissioners?
None.
Well, since you took my question. I have no more questions.
I was trying to save you some trouble.
You did.
I think I was going to use that one this time.
Okay.
All right. Now, with respect to guilt or innocence, sir, I see that, first of all, before I find a charge, I see that you have had a previous experience with the same charge. Is that right?
Yes, actually. I was moving at a short sale on the June.
This was July 2nd.
Yes, so I was at the time, this stage, I had to move, and then when I move, I have no address to move, so I just put all the stuff in storage, and then I put it out. So after, actually, I finished up the moving on the end of July, but I have to keep working for moving up the storage, some in the basement, so physically, I was really
Now, when did you take over this license?
11 years ago.
So I don't understand your point about moving.
Oh, okay. So actually, my point is recently I was, really stressed and I was physically really tired. That's why
You were careless.
I didn't do what I did right. So
In other words, you're explaining how it happened.
yes, and but I was actually physically recovered now. So I think I feel like I gotta do whatever I do, including check ID of everybody.
All right, commissioners, questions?
No questions.
Just one comment. You appeared before the board on July 24th, 2014. I'm not sure that's the date you gave when you made the statement.
I have the date of this charge, the 2nd of September, 2014.
I'm talking about first time.
The record date, I have July 24th, you're right, July 24th,
Yes.
2014, not July 2nd. What is we're talking about?
And that was from a February violation.
Yeah. All right.
I did twice in this month, but at the time, recently I was really.
Well, you can't
too
be
much.
careless about this,
Yeah.
sir. That's you got to be very, very strict about age. And all of us have trouble identifying ages of people. Now, for example, I thought she was 16 instead of 20. But on other occasions, he's brought witnesses in here that I thought looked like in their 20s, but you just can't go by that. You gotta check them. I find you responsible.
I have no intention to send anybody, but it was mistakenly, as I said, maybe. Was physically so tired recently, that's why.
Well, my decision is finding you responsible for the charge, and $1,000 fine plus cost. How much time do you need to pay it?
60 days.
60 days. Commissioners?
I agree.
All right, you have our decision. That is our decision. $1,000 plus cost, 60 days to pay. And you make your arrangements over here. Thank you. Call the next case.
Yes, sir. The next case is Ashtok Patel, W. Kumar Patel. This is at Kalen Plus, Inc., trade name Bernie's Liquors. This is at 2527 Washington Boulevard. This is a Class A beer, wine, and liquor. A violation of 401A. No licensee shall sell or furnish alcoholic beverages to any person under the age of 21 years of age with the knowledge that such person is purchasing or acquiring beverages for the consumption of any person under 21 years of age. September 2nd, 2014. Alcoholic beverages were sold to a cadet. And that's it. The previous case was postponed.
Okay.
You talking
3916.
Just for the record, that the previous case on Maynard's was, on Maynard's Cafe was postponed. And there was a request for postponement, so that's why we were.
We're here on the case of 1269 Washington Boulevard.
Yes, 25.
You shouldn't have put that up. I don't know what you're talking about.
2527, sir.
No, I have 1226.
You went, just like I did, you went too far one. It's this one.
Hold the tag.
Yeah, they're the tab. These tabs are,
Yeah,
there you go.
So we're here on 2527 Washington Boulevard.
Yes,
Mr.
sir.
Kudinski.
For the record, I'm Jay Kensky, 19 East Fayette Street, representing the licenses. Will be an admission and waive the reading thereof, except the police report is a correct statement of facts.
All right. Officer Akawande, first of all, swear all the witnesses, please.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Officer Akawande, he's admitting the facts, which states, and you can correct me if I'm wrong, on September 2nd, 2014, alcohol was sold to an underage police cadet who you sent in for that purpose of buying, which was done. You recovered your property, turned out to be alcohol, and all of this occurred in the year 2014. Any additions or corrections to that?
No, Your Honor.
All right. And Officer Niger, your testimony would be the same?
Yes, sir.
All right. And ma'am?
I'm president of our community association.
Okay. State your name, please.
I'm Carol Ann McCoy.
Ms. McCoy, come over and tell us what you'd like to tell us.
Well, first of all, I'd like to thank the Vice Squad. The youth in Baltimore City, especially Morrow Park, is off the hook. And
Morrow Park is all what?
the kids are off the hook. They're just out of control, the youth. And being served is just an addition to this menace that we have. Now, this is not the first time that this bar has had this problem. And I think that the owner should realize it's a privilege and an honor to have a liquor license. We have 9 liquor establishments in a 3-block radius. And I think that we could do with one less. Now, out of all goodness, this is a businessman, and I did go to him,
And I shared that I realized he
Who
was,
did you go to?
I went to the owner, it's that gentleman right there, because his brother owns Dunkin' Donuts.
Okay, state your name, please. Who we're talking about. Are you Mr. Patel?
Ashok.
Okay. Now, your first name is Ashok Patel? Yes. Okay, go ahead, ma'am.
I went to him and I said, perhaps you should ask for a postponement and come to the community association and share how you can improve to be a good community partner, because we do have many of them, and it is his livelihood. And he said he would, but I called yesterday, it wasn't postponed, no attempt has been made. We have a little league that we struggle to keep 100 kids playing. People don't have the money for it, so we support that. The community partners support that. Mr. Patel does not support anything in that nature. I checked with the Little League last evening. That was not the case. I did my homework. Plus,
Okay.
it's already been okay.
I gotta wait until she finishes, and then you go, whether your lawyer wants to ask her any questions. Gotta be courteous. All right, ma'am, go ahead.
And it's been 3 times previous that this has happened.
Three times?
3 times. I think it's
Well,
2005,
now, let's see.
7.
I have a record here of September 22nd, 2011, and that's the only one I
Go
have.
back to 2005. I think it was 2005, 2007, and 2009, I believe.
Check that, please.
Yes, I'm having her pull up.
Checking.
I'm calling it right here for you.
Because I come down here, the gentleman will tell you, the liquor board's chair, if there's a bar in Moore Park serving minors, I'm here. And they will tell you they know me. And it's just, if
Just
you've
let
done
us
this.
see if we have it.
Yes, sir. There was a violation of 401 on November 23rd, 2009. There was a violation of 401 and 3.03, and there was a guilty decision.
Wait a minute, now, that's 2009.
2009.
Mhm.
And in 2000, I'm going to continue, okay? In 2005, there was a hearing and a violation on October 13th, 2005, where they were found guilty of 401 and 303C, and they were found guilty and charged $3,000 or 30 days suspended.
And that was 3,000 on 2005.
Correct. And then back in 2000, we have, there was a public hearing in February of 2005 where there was a violation of Rule 401A and 4.18. And so and then.
Wait a minute, now, slow down.
Sorry.
To February 5th, 2000.
February 28th.
28th, 2005. you said.
Correct. Yes, sir.
And that's the second one in 2005.
Yes.
And that's a 401, that's a minor.
Mm-hmm. And
what was it?
418, which is illegal.
For what?
418.
What's that?
That's illegal conduct.
And what was it? You don't have any facts.
No, I'd have to, and those are archived at this point.
All right, and what was it finding? What was the penalty?
That 418 was dismissed, but they were found guilty on 401.
And how much?
$625.
All right, and what else?
And then in 2004, there was a violation, but that's an administrative one. So that's the last, so it was all in 2005. That's an administrative, not trader's license.
Well, then we have September 22nd, 2011, don't we?
Yes, in 2011. I didn't read that one on September.
And that was a $1,750 fine.
Correct.
Which was reduced to $625.
Correct.
So they actually went down in fine after the, let's see, it's 1, 2, 3 violations. Is that correct?
Correct. On the full history, that's where we are.
Okay. Be glad to hear from you, sir. Oh, ma'am, do you finish?
No, not yet.
Okay.
And I think 3 strikes, you should be out, because I'm saying that you have to learn a lesson.
Well, in baseball, 3 strikes, you are out.
Okay, but I'm just saying, you have to learn a lesson. If you did it wrong once, okay, correct whatever's wrong, and we'll give you another shot. Well, how many times are we gonna keep doing this?
So what do you want us to do?
I think they need to be closed. I think it needs to be closed. I've gone and tried to do everything I can, approach them, come to the community. It's just not working. And we have too many bars in our neighborhood as it is. And I just feel as though that we could do with something else better.
All right, questions? Council first?
You're having a meeting in a week or so?
We have one every month, sir. It's nothing new.
I'm just asking you a question.
Okay.
I mean.
Mhm.
And they're going to come to your meeting?
I have no idea. They've been invited. I have
When you
no idea.
ask them for a postponement, you understand this board has a 72-hour rule. They couldn't have got a postponement.
So,
No, I'm just asking if you understand. You don't have to argue with me.
I'm familiar with the board and they're familiar with me. okay? And I realize it's a 72-hour. I'm just hoping that they realize it's a privilege and an honor.
They understand. I'm only asking you a question.
Okay.
All right, tell the board what you want to say.
You'll get your chance.
Oh, I'm sorry, I don't know if she's done it.
We're just on questions to her.
Yeah, I'm finished.
Commissioners?
None.
Okay, all right, so just doing the history, so there were 2 violations in 2005, 1 in 2009, 1 in 2011, and then this is the first in 2014.
It's the same owner.
That is the history, correct? And am I correct in understanding that you or your community association has invited them to come in and discuss
And each time
this
there's been a
issue?
violation, I've been here.
Okay, and I know what a commitment that is to,
Taking off from work and
exactly, and to be here. And that's what community is about. But going to the community, they are coming in, you believe, at least an invitation has been extended for them to come in and talk about what they can do better. And if I'm hearing correctly, you've expressed some needs of the community that you feel they could help address.
And they've been approached and haven't. And I checked with the Little League president last night to make sure, because I know it was coming here today.
And is that an issue that you feel would be discussed when they come to the meeting in
Well,
October?
letters are sent to them when Little League season begins, because people can't afford it to have 5 kids to pay for the kids to go to Little League. So we don't want any kid left out. We let them all play. But there's fees that have to be paid, equipment, uniforms, the whole process.
It's very important. Okay, I think those are all the questions that I have.
Any questions resolve that? All right. Now, with respect to any other witnesses, you go to the defense.
You want to give your name and address for the record?
I shall.
Now, regarding the community meeting, are you going, you told me you were going to go to the community meeting, is that correct?
Yeah.
And then how about your participation, either you and your brother in the community? You mentioned that that you did participate in the community, is that correct?
We are supporting to the community and we are supporting to the Little League too, but I am not sure that Mikal knows or not, but I did talk with you on Wednesday night and I tried that, you know, and my brother gave you promise to come in your meeting, in future meeting, like. And we would be there. And we would be there.
Okay.
All right. That's it, sir.
And what have you done with regarding this particular instance in which the cadet was served? What did you do? You're having your people all of them take the alcohol awareness course, is that correct?
Yes.
And then since then, because you know that you've had that problem every couple of years, something would come up. Is that correct?
Yeah.
Okay. I have no further questions.
Commissioners, questions?
Recently, is that the first time you ever been invited to a community meeting? And if so, have you been to one prior to that invitation?
No, this is first time.
How long have you been in that community?
More than 11 years. This is 12 years.
Do you feel like you're part of that community?
We are the part of the community, but we supporting to the community too. And lot of community, most of community around there is knowing me and I know them too. And when they come for anything, like, we are supporting for everything. Sure.
So why haven't you seeked out the community meeting location and date and tried to attend? Why haven't you attended any meetings on your own without them asking you? Because you say you do feel like you're part of that community.
I would attend.
Why haven't you done it before?
We didn't attend the meeting, but we supporting, that's I know.
Thank you.
Well, let me just ask you.
I have one question. And to clarify,
Yes, your name again.
I'm Carol-Ann McCoy, President of Mall Park Community Association.
Yes.
But
Just on this narrow point. did
right,
you have
his
something?
brother
No, the question
is PG.
Did you invite him before this last time?
They're handed letters, always inviting them, asking them to support certain events, particularly our Little League and the big parade
Well,
that's
just,
held
ma'am,
yearly.
Did you, before this last time, invite him or his associate with him today to any community meetings?
Letters
That
were
was
even
the
placed.
commissioner's question.
Letters were even placed, because we fought CSX, I don't know if you're aware of that, and letters were even placed to establishments asking everyone to come to huge town hall meetings.
So the answer is yes or no?
The answer is yes.
Okay, hang on a minute. Go ahead, sir.
All right, you had mentioned something about the Dunkin' Donuts. Is that your family owns a Dunkin' Donuts?
Yes, my brother.
And they're part of the community also?
Yeah,
And
he's
you
the part of
support the
we are
community?
all part of the community, like 3-4 stores.
You say your brother supports the community through Dunkin' Donuts?
My brother supports and
How
we
does he do
supports
that?
too, but
He gives him donuts or what? I don't know. Sometimes.
yeah, he gives them donut, we gives them cold drinks and whatever they need at the time of the meeting of the community. We support it, but I don't have any return like, you know. It's like,
You're not a part owner of the Dunkin' Donuts?
no, sorry.
Anything else, sir?
No,
All
it's-
right, commissioners' questions.
None.
Can I just clarify?
No
one-
questions.
Mr. Gudinski, what do we have to do to stop this from happening again? Do we have to close this bar for good, for a penalty period, a tremendous fine again, or some other kind of arrangement that will remind this owner that this kind of conduct has to stop? What do we have to do?
My answer to your question, maybe not the answer, is that I had talked with Mr. Patel, and he had mentioned that he had talked to Ms. McCoy. I said, I can't get a postponement because it's a violation case, and he said, I'm gonna meet with the community, I'm gonna try to find out where the problem area is and work with the community.
Has to
along with-
find out where the
No, no,
problem
with his-
is?
Well, as with regard to, it's a cadet service, it wasn't a service of people coming in, they were caught coming out with alcohol, like you said. So I'm not trying to downplay it, but I mean, it's not like this cadet wasn't served anywhere else. They're in the community, they have a couple businesses there, you know, they want to try to help out the best they can, but every 3 years, it seems like they pop up here. I mean, I can't explain that, I don't know whether it's a 3-year syndrome or what it is. It's not like they're Johnny-come-latelys, they just haven't just popped into the neighborhood.
Well, I'll find him, first of all, responsible for the charge. And with respect to my decision, I'm not totally satisfied with the suggestions of going to a meeting. We'll, after having been invited in the past and never attended a meeting, and this constant repetition. So I'm going to close him for 1 week, beginning immediately, and a fine of $3,000. And of course, plus cost and how much time he needed.
30 days? 30 days.
Commissioner?
I agree.
So
30 days is okay with me.
I agree, and I would just like to take the opportunity to drive home the point that you are in the community. Washington Boulevard is spine through that neighborhood. I was at your brother's Dunkin' Donuts just this week. I didn't realize that that it was that establishment, very well run. And your brother could be a model for you. I think, not to be on a soapbox, but to be on a soapbox. The need in the community is large. One of the things that I did observe on the couple of visits that I've made through that area, because I'm on the liquor board, I want to know what it is that comes before us. So I have driven through there, and I have noticed clusters of young people looking like they don't have much to do. Little League is extremely important. Little League changes lives. And if you and your store could be part of that, we don't have the authority to, I don't think we have the authority to require that, but if you and your liquor store could be involved in some way, you really are not just helping yourself, you are helping yourself. You're not just helping the community, you are helping the community, but you have the potential to dramatically change the life of a Baltimore City child. It's really needed, and it would, the dividends to you from that would be tremendous. So I agree with the finding of responsibility. I agree with the finding of the fine, and hope that my soapbox speech has some resonance with you. Okay, thank you.
You have our decision. Sir, ma'am, Paul Weisgoff, I used to know very well.
Yes.
He never comes back anymore, does he?
Yes, he does.
Does he?
He's in Delaware, but yes, he does come by.
Good.
Comes over to Paul's and our beauties.
Mhm.
We have breakfast there sometimes. And,
Okay,
oh, yes, they're still around.
good, thank you.
But I heard very kind words about you a long time ago from a good friend of mine, George Della.
Oh, well, he was here earlier this morning.
Oh, was he?
Yeah, thank you.
So, you know, thank you all very much. But you're right about PG. That's how I felt.
Okay.
I had to go to PG to get them.
So I had a delicious new breakfast sandwich, spicy sauce.
I just want to make sure.
We get all the notes.
Are you on this one?
Might as well take it.
Rajwan Kapoor and Samir I'm sorry, I forgot saying this. Is that 1269 Washington Inc., trade name Chris Liquors and Grill. This again is at 1269 Washington Boulevard. This is a BB7 beer, wine, and liquor license. This is a violation of 401A, sale to minors. No licensee shall sell, furnish, or provide alcoholic beverages to anyone under 21 years of age or to any person with the knowledge that such person is purchasing or acquiring such beverages for the consumption by any person under 21 years of age. September 2nd, 2014, alcoholic beverages sold to a minor cadet.
For the record, Melvin J. Kanensky, 19 East Face Street, representing licensee. This would be an admission, accept the report as written.
All right. Swear all witnesses, please.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
And I will read the facts into the record, maybe speed it up a little bit, since this is an admission. On a 401, a violation of selling alcohol to a person under the age of 21, Officer Alkawandi, who are here, with the facts show that on September 2nd, 2014, that this did in fact occur at 1269 Washington Boulevard, resulting in you were sending in a cadet who was present here also, Officer Nazar, who in fact did purchase alcohol, which was recovered by your squad and then returned after being marked into evidence. So those are the facts.
That is correct, Mr. Chairman.
Any additions or corrections?
No, Mr. Chairman.
Any questions?
No questions.
Any questions of the commission?
None.
With respect to findings, I'll be glad to hear from you.
This licensee's probably been a licensee for less than a year. She took over, I think it was transferred in December of 13 or January 14. I've instructed her that she has to get all her employees certified, and they must absolutely request.
Now, who is she?
The lady right here is your.
Your name, ma'am?
State your name.
Ryan Kaur.
Ms. Cower.
A-A-U-R.
Yes.
And you are the licensee.
Yes.
Is that correct? Do you speak English?
Yes.
Okay. Because I wasn't sure.
I'll explain that to her, and to make sure she tells all her employees to do that, to make sure she checks the photo ID and so forth. And I think she's seen and listened, she here the whole day as to what possibly could happen if she was not going to go ahead and do that. And this was not an isolated instance in which this cadet was served. She was probably served in every place that she went into. So you hope that adage, once bitten, twice shy, would apply here.
Well, that's why she brings a good lawyer like you. Any questions of commissioners?
None.
All right.
No questions.
Ready for the decision. Anything else?
Nothing.
With respect to the charges, the finding of responsibility is found, and $500 plus costs, how much time she need to pay it?
Huh? You want to pay it today? She'll pay it today.
All right. You have our, commissioners,
I agree.
I agree.
you have our decision.
Thank you very much.
That concludes your docket, sir.
All right, that concludes our docket. Thank you very much.
4020 Lombard is postponed. That is in postponed. 4020 is postponed.
Oh, that's good. I mean, that good lawyer did a good job today. A good lawyer. Boy,
But you were talking about John Janetsky. He lived on Bank Street. So he used to walk down, and he was a St. Patrick's guy. And
St. Patrick's
church.
Oh, the church.
Yeah.
So he also had a club, St. Patrick's.
Yeah, and that just recently disbanded.
I know.
Just recently, they just sold their property. And in fact, today I got a call from Gene Rayner. And Gene said, I remember, John Janetsky. And then we start talking. I couldn't get him off the phone. Gene has not been real well, but it seems like he's doing okay now. If you ever go to Vaqueros, he has his own booth there.
I was there recently with him for lunch.
He sat in his booth. The Rayner
I don't know
booth.
what he does himself.
The judge knows everybody. I mean, he gets around.
Well, that's what you got to do. It's hard.
I didn't know you before here.
It's hard to hit a moving target. It's hard to hit a moving target, right? You keep moving.
Me and Judge gonna be hanging out together in a little while.
I know.
Hey, look,
We're
that's
not,
what we do. That's my
Joe,
man.
you don't
I
have
like
to tell me.
Yeah.
I got the pictures, they'll look
That's right.
fine as sky.
Hey, hey.
Folks, thanks.
Thank you, Josh. Good job. Good job.
How thorough?
I left it, that's why I just couldn't go.
No, that's all right. You
Chairman,
Yeah,
we're not going to meet on Tuesday anymore. I'm going to change the day because there's some conflicts with the other council.
I don't know what you're talking about.
Tuesday for the interviews, we're not going to be able to do.
Oh, you
Tuesday.
canceled that?
Yes, I'm going to cancel
Okay.
that. I just want to let you know so that you can do your appointments.
All right, give me a date when you get it.
I will, sir.
Folks, I'm running.